Sections 2, 3 and 4 of the Dowry Prohibition Act were primarily looked into. The High Court referred to Nunna Venkateswaralu's case, where the single judge held that the definition of dowry contemplates that there must be an agreement either before, after or at the time of marriage for exchange of valuable security or property, and unless such agreement has been proved to be on record, a person cannot be held guilty for an exchange of dowry under Dowry Prohibition Act of 1961. The single judge pronounced the judgment based on the decision of the division bench in the case of Ayala Rambabu. For identifying whether the cases were good in law or not, the High Court referred to the case of Pawan Kumar versus State of Haryana, in which the Supreme Court had held that the intention of Dowry Prohibition Act 1961 is to penalize any demand for dowry irrespective of whether the demand was direct or indirect and whether or not there was an agreement to the effect. Further, there is also a discussion of this case of Prem Singh versus State of Haryana, in which the Supreme Court had held that additional demand for dowry can also be covered within the meaning of dowry in section 2 of the Dowry Prohibition Act. The words "at any time after the marriage" may appear to be of an unlimited span of time, but the court held that the more significant words are "in connection with the marriage of the parties." Now, at this juncture, it will be relevant for us to look into the details of and the specifics of the words "at any point of time after marriage," which has been discussed in the case of Prem Singh versus State of Haryana. Now, when we say or look into the Dowry Prohibition Act 1961, we try to discuss the concept at any point of time, the span of time which seems to have been covered looks very large in its scope and very unlimited in its scope. But the idea is whether we can keep on punishing an individual for demanding dowry for an entire lifespan of a woman concerned, or is there any limitation in terms of in terms of the duration, for instance, maybe like for instance when we talk of dowry death under section 304B of the Indian Penal Code, the span of 7 years is relevant. So, any death in connection with dowry is presumed to be a dowry death if the death happens within the span of 7 years. But the terms at any point of time after marriage, which have been captured in the Dowry Prohibition Act of 1961 need to be looked into with a little bit of analysis here. So, here we have to read these terms in connection with the words "in connection with marriage." So, when we say that the demand for dowry has been there, what is more relevant is, was the demand for valuable security or property made in connection with marriage? Now, at what point of time after marriage it was made is not as much a factor which requires discussion, as it is important for us to find out whether such marriage such demand was made in connection with the marriage between the two parties. Now, after the Dowry Prohibition Act, I think it will be pertinent for us to also look into the provisions made under section 304B of the Indian Penal Code, which is again a major piece of law which was introduced by way of an amendment after the Dowry Prohibition Act was passed. The amendment was made in the Indian Penal Code to cater to the needs of those women by punishing the perpetrators of a crime under 304B against such women. So, there are primarily, as the concept of 304B, the term dowry death would itself connote, there are primarily two important figures here that we need to note. First, it must be a case of dowry, and of course, it must have resulted in the death of the woman. So, the provisions under this section are attracted only when the woman has died as a consequence of a demand for dowry. So, the ingredients under this section can be captured as, first and foremost, the death of a woman must have ensued within 7 years of her marriage. Such death may have been caused by burns, bodily injury, or under circumstances which are not otherwise normal. The woman should have been subjected to cruelty soon before her death. Such cruelty must be meted out by the husband or any of his relatives in connection with a demand for dowry. Now, an explanation of these ingredients is pertinent at this point. So, the first requirement says that a woman must have died within 7 years of her marriage. Such death should be abnormal, or it should not be under natural circumstances or normal circumstances. So, what is exactly connoted by the term normal circumstances or natural circumstances? So, for instance, a woman who dies out of sickness for a prolonged period of time, or who dies because of some sort of injury that she has received, or some kind of ailment that she has been going through for a long period of time, they are all covered within natural processes of death. Now, when we say abnormal situations or unnatural conditions, it has a bit of a history which I think will be important for us to discuss right here. Now, during 1960s and in fact before the 1960s, before the Dowry Prohibition Act also came into the picture, and sometime also after the DP Act came into the picture, we had the phenomenon which was tagged as bride burning in India. Now, bride burning is a concept with which all Indians are familiar, wherein the woman or the bride may be a newly married woman, or a woman who had been married for a couple of years of her marriage. Many of them, they faced a death in the kitchen. Now, the stove accidents or the accidents because of bursting of a gas cylinder was so common in Indian matrimonial homes that they started gathering attention as to why such things were happening. So, it was very common at that point of time to have women dying in the kitchen while they were cooking. Probably the kitchen was considered to be a perfect place for committing the murder of a woman who had not really brought the amount of dowry that was expected by her in-laws. So, the woman formed the perfect victim, the kitchen formed the perfect scene for killing the woman, because women were generally associated with the kitchen. And of course, the perpetrators were the husband, the relatives of the husband, and the number of such crimes started increasing at a phenomenal rate over a period of time in India. Now, to counter such measures, we had brought into picture the section 304B, which was thought to address the problem pertaining to dowry death in India. So, which is why the terms here become relevant, the term killing a woman or the death of a woman under circumstances which are otherwise not normal. So, the death also may be caused by burns or bodily injuries, or under any such circumstance which does not appear to be normal. The woman, again, the third ingredient that I had mentioned was that she should have been subjected to cruelty soon before her death. What is the connotation of the term soon before? We will be discussing very soon in the later part of the lecture. And the last point is that such cruelty should be meted out by the husband or any of his relatives in connection with the demand for dowry. Now, the last two points are interrelated, so we would like to examine them or discuss them by referring to certain case laws by the High Court or the Supreme Court.